Hi everyone, my name is Kuminji. Today we are going to talk about the case of Donoghue and Stevenson and the neighbor of principle. Donoghue and Stevenson or Scottish dispute is a famous case in English law which was instrumental in shaping the law of tort and the doctrine of negligence in particular. Before starting to analyze the case of Donoghue and Stevenson, I would like to introduce the pre-Donoghue and the law of negligence. Before the case of Donoghue and Stevenson, a plaintiff cannot bring tort claim against a defendant for non-feasance that resulted from a contract which plaintiff was not privy to. This principle is clearly stated in the case of Winterbottom and Wright, 1842. In this case, a plaintiff, a mail coach driver, was seriously injured when a vehicle broke down due to lack of repair. Defendant had contract with the Postmaster General to keep the coach in safe and secure condition. Defendant failed to comply with the promise, resulting in plaintiff injury. These issues has been raised was, does defendant own a duty of care to plaintiff such that he is liable for injury caused to plaintiff caused by defendant negligence? In this case, the court held that the defendant is not liable because the plaintiff is not privy to the contract entered into between the defendant and the Postmaster General. Just as the plaintiff cannot sue the contract, he cannot sue in tort, claiming that defendant owed a duty to him. Heaven and Pinter, 1883, was an English law tort case which foreshadows the birth of the modern law of negligence. In this case, the plaintiff was a painter. His employer engaged to repaint a ship, and the defendant is later stating to support the work. The staging collapsed because one of the rods was seen and weakened, resulting in injuring the plaintiff. The defendant was held liable because the defendant had invited the plaintiff onto the land, and he knew he would be using the staging. This case established that under certain circumstances, one might own a duty to another, even if no contract. The landmark case of Donoghue and Stevenson 1932 became very important. As a result of this case, the legal principle of duty of care was formed, and there was a clear neighbor principle defined by Lord Akin. The following video will be done by firstly introduce the phase and issue of the Donoghue and Stevenson, followed by discussing the downside of the essence of negligence and duty of care, the neighbor principle, and the judgment and significance of the case of Donoghue and Stevenson.
Hi, I'm co-player Samantha. So I'll be talking about the case facts of Donoghue and Stevenson. This case happened in Paisley, Scotland in 1928. At the cafe, Mrs. Donoghue was given a bottle of ginger beer, which was purchased by her friend. The waiter poured some of the ginger beer onto the ice cream. Later, Mrs. Donoghue's friend poured the rest of the ginger beer and found out that there was a decomposing snail in the ginger beer bottle. Since the bottle was not made of clear glass, Mrs. Donoghue consumed most of its contents before she became aware of the snail. She later felt ill, and the physician diagnosed her with gastroenteritis. Mrs. Donoghue subsequently took legal action against Mr. Stevenson. the manufacturer of the ginger beer. She lodged a raid in the Courts of Sessions, Scotland's highest civil court, seeking for £500 of damages. So what are the issues in this case? Firstly, whether Stevenson owed a duty of care to Donoghue. Was the relationship between them sufficiently close that Stevenson should be required by law to exercise a certain degree of duty of care in carrying out a particular task? Secondly, could a manufacturer owe a duty of care to the ultimate consumer of goods? This was stated by Lord Atkins. Thirdly, is there a contractual relationship between Mrs. Donoghue and Mr. Stevenson, as the ginger beer was bought by her friend but not her?
Hello, my name is Hasha Akila, and today I'll be explaining about neighbor principle and also liability of manufacturer. We'll start off with neighbor principle. Neighbor principle is an objective test which was developed by Lord Atkins in the case of Donoghue and Stevenson back in 1932 to establish when a duty of care might arise. It is clear that the principle does not open to floodgates to unlimited claims, because a tortfeasor will not held to owe a duty of care to those who are not close to be in his or her contemplation at the moment of the tortious act or omission. The famous neighbor principle can be found in the opinion of Lord Atkins in the following passage of the Donoghue case. It was summarized that the rule that you are to love your neighbor becomes in law. You must not injure your neighbor. You must take care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. The big question here is, who in law is my neighbor? So the answer is people who are closely and directly affected to my act, and I ought reasonably to have them in contemplation as being so affected when I am directly in my mind to acts or omission which are called in question. To make it easier for you to understand, let me ask you, would a reasonable man who is in the same circumstances as the defendant foresee that his conduct will adversely affect the plaintiff? If the answer is no, then the plaintiff is not his neighbor. Hence, no duty of care arises. But if the answer is yes, then the plaintiff is considered as the neighbor of the defendant and that he owes the former a duty of care. Donoghue case is indicated by Mark Looney and Ken Oliphant, stated that is probably best known for Lord Atkins' neighbor principle. As can be seen from the majority speeches, it does not form part of the ratio of the case. The same proposition was made by Professor Houston as early as 1959, when he said that the neighbor principle, although perhaps the most commonly cited and in many ways the most significant, cannot probably be regarded as part of the ratio decidendi of the decision. Despite being regarded as the dicta of the case, the neighbor principle is greatly influenced in tort law and was not overruled up until now. Moving on, we will proceed on liability of the manufacturers. Manufacturer's liability is a legal concept or doctrine that holds manufacturers or sellers responsible or liable for harm caused by defective products sold in the marketplace. Manufacturer's liability is usually determined on any three bases. One is the negligence, which is the failure to exercise reasonable care to prevent product defects arising on the manufacturing process, or which is the failure to give consumers appropriate warning of a danger attending the use of manufacturer's product. Secondly is the breach of warranty, which entails failure to fulfill the terms of claim or promise concerning the quality or performance of a particular product. And lastly is the strict liability, in which a seller or manufacturer can be held liable for a defective product even if the conditions of negligence or breach of warranty do not apply. An active consumerism movement is credited with the courts increasing acceptance of arguments based on the manufacturer's liability. Lord Acnin stated on the liability of manufacturers in Donoghue's case, a manufacturer of products which he sells in such a form as to show that he intends to reach the ultimate consumer in the form in which they left him with no reasonable possibility of intermediate examination, and with the knowledge that the absence of reasonable care in the preparation or putting out of the products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. Next is Lord Macmillan. He stated also about liability of manufacturers. He stated that a person who for gains engages in the business of manufacturing articles of food and drink intended for consumption by members of the public in the form in which he issues them is under a duty to take care in the manufacture of these articles. That duty, in Lord Macmillan's opinion, he owes to those who intend to consume his products. He manufactures his commodities of human consumption. By reason of that very fact, he places himself in a relationship with all potential consumers of his commodities, and that relationship which he assumes and desires for his own ends imposes upon him a duty to take care to avoid injuring them. That is all.
Hello, my name is Amir Wazir Amjad bin Abdul Maulud, and today I would like to talk about the dissenting judgment from the case of Donoghue versus Stevenson. In that case, the judge that dissented that the judgment in the case of Donoghue versus Stevenson was called Lord Buckmaster, where he adopted an almost completely opposite interpretation of the existing cases to Lord Atkin. He argued that the general rule was that there was no duty of care owed to a third party outside of a contract. The exception to this were for objects dangerous in themselves, such as a gun in the case of Landry versus Levy, and defects that were known to the manufacturer, like fraud in the case of Winterbottom versus Wright. He then dealt with the very few cases, mainly with obiter dicta statements, which might be seen to support a duty of care in other cases, such as that in Donoghue versus Stevenson. While he thought some of this could be used to impose a duty of care on Stevenson, he also considered them contrary to the clear line of decisions and felt they should be buried so securely that their perturbed spirits shall no longer vex the law, such as in the case of Donoghue versus Stevenson. He saw those cases where physical proximity was involved as belonging to a clearly different category, and argued that the established distinction between dangerous and non-dangerous objects in the case law would be meaningless if the duty of care existed all along in both cases. He also said the logical consequences of imposing a duty would extend to all types of objects and to all people who lawfully use them. In this, Lord Buckmaster implied it would not be socially or economically accepted for manufacturing businesses to be open to claims from such a wide group of people as if a duty was imposed. That is all for me. I shall pass it along to my group member to explain about the judgment and significance of Donoghue versus Stevenson.
Hi everyone, I'm Samantha, and right now I'm going to talk about the judgment from Donoghue and Stevenson. In the House of Lords, it was established that a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him with no reasonable possibility of intermediate examination, and with the knowledge that the absence of reasonable care in the preparation or the putting up to the products will result in an injury to the consumer's life or property, owes a duty to the consumer to take reasonable care. This would mean that a manufacturer of product owes a duty of care to its consumers. The appeal by Mrs. Donoghue was allowed. Now, moving on to the significance of Donoghue and Stevenson. In this case, there was two main significance that came out as a result of this case. The first one would be the privity fallacy. In Donoghue and Stevenson, the majority of House of Lords held that the existence of a contract between the defendant and a third party did not prevent a duty for the defendant in relation to the performance of the contract. This would mean that the privity of contract fallacy was exposed. After Donoghue, the existence of a contract between the defendant and a third party has rarely affected the defendant's tort liability to a claimant who suffers personal injury. However, it should be noted that Lord Buckmaster's floodgate argument, as discussed earlier, have proven to be much more persuasive in cases involving pure economic loss. Now, the second significance that came out of this case would be Lord Atkin's neighbour principle. Lord Atkin's speech became renowned for its articulation in the neighbour principle, which was based on his religious belief of loving your neighbour. This principle was the foundation for the tort of negligence that we have today.
So in conclusion, this case is the beginning of the tort negligence which have affected the law regarding the purity of contract and duty of care. Also, neighbour principle is essential in Donoghue and Stevenson, which is one of the landmark cases in law of tort. Proximity and feasibility must occur to fulfill the neighbour principle. Thank you.